Bharati case took place. Now, please come to the next case, which I've just taken 3 or 4 cases in a shortage of time. Now, I come to the ADM Jabalpur case, and I would request all of you to read the minority judgment of Khanna. It contains the entire essence of interpretation of the Constitution. I think perhaps no other judgment in one single judgment contains so many multiple principles of interpretation as Justice Khanna had. Now, I would like you to visualize the emergency. My young friends may not have been born at that time, but I've lived through it. I was in college in Bombay, and we had complete emergency, no freedom of press, nothing. Now, please see the first point, Article 21 and 22, right to liberty, preventive detention, 22, plus presidential proclamation under 395. Effectively, what they said was, your right to approach the courts for violation of 21 and 22 is completely gone. So, textual interpretation on 21 and 22, read the articles and read the presidential proclamation, strict construction. So, the majority said that putting these together, nobody can approach the court. Now, it is interesting to read the High Court judgments. Don't just read ADM Jabalpur. Read some of the High Court judgments from Bombay, Nagpur, and so on. What the High Court said was, 21 is suspended, no problem. 22 is gone, no problem. But if the person has been detained under MISA, that is Maintenance of Internal Security Act, the dreaded MISA as it was called, but the provisions of MISA are not satisfied or have been violated, then we can set aside the detention and grant relief on the ground of violation of MISA and not because 21 is affected. 21 is still there, but if the statutory provisions are invalid, have not been complied with, he has to be set free. And they said 226, there is no limitation. We have got powers to do it. The word is other purposes. But sadly, High Courts are overruled. And the Supreme Court said, even if the detention was contrary to any law, any regulation, still High Court had no power under 226 to set at right a person, even if the detention is invalid. And they said that even if your fundamental rights are not violated, no relief. They simply said, yes, your detention is invalid. You must read the majority judgment. They say, yes, the detention was invalid, but your right to approach the court is gone. In other words, there is a right, but there is no remedy during the remedy. Now, please come to Khanna's judgment. Now, in this historical background, where there is sort of darkness as far as all human rights are concerned, everything is suspended, courts have gone complete into the limbo, then the 42nd Amendment followed. But you must see Khanna's judgments, the way he applies multiple theories and says that, look, notwithstanding the emergency, notwithstanding suspension of all rights, the right to life still remains, the powers of the High Court and the Supreme Court still remain. Now look at what he does. First, it's not a very big judgment, it's about 100 paragraphs, and I would recommend everybody read it. He first starts off with Plato, goes to the Magna Carta, goes to the US Supreme Court. He then goes to the judgments of Lord Atkin and so on in the Second World War, where despite the emergency powers, the courts interfered in certain cases. So he goes into all that. Then, second part. So the first part is like a historical part of the interpretation, theory of interpretation. Then 21. Khanna makes a very important point. He says that 21 is not the source of right to life. He says go to pre-1950. Go to section 491 of the CRPC. Even before independence, in colonial Britain, in England, colonial India, you had the right of habeas corpus. A magistrate could, powers of the habeas corpus were there with the criminal courts. So he says the right to life is not granted by 21. Right to life exists. Then the next point, which I think is absolutely magnificent, is the rule of law. In about 18 or 19 paragraphs, Justice Khanna discusses rule of law and says that in a country of rule of law, notwithstanding suspension of right, rule of law still prevails, that can never be taken away. Please go to the next slide. After analyzing, he makes a very passionate plea. You can see always the man grappling, struggling to give relief. He says If you accept that 21 is gone, 22 is gone, and you have no remedy before any court, what are you saying? What is the consequence of what you're saying? You are saying that the executive is not governed by any law. The executive is not answerable to any court. And that, he says, is not permissible under our constitution, notwithstanding suspension of these rights. He then goes on to UN Declaration of Human Rights, that we have signed the charter. Then he again goes to historical method of interpretation. He says, look at the US Constitution. Now, the argument was under Article 226, you can issue writ of mandamus, certiorari, quo warranto, and habeas corpus. The presidential proclamation does not suspend Article 226. And Justice Khanna says, look at Article 1, Section 9 of the US Constitution. There, habeas corpus can be suspended in terms of armed rebellion and certain other cases. He says, we have got Article 226, we have got the habeas corpus, but we never included that provision. So if you go by textualism also, go by historical provisions also, Khanna says there is no way you can take away right and liberty. And finally, he makes a conclusion and 12 reasons. And to my audience, I would suggest, I would strongly recommend you please read this minority judgment. And to make it easier and more enjoyable, I may use the word, go to his conclusion in para 220 of the AR reports. 12 reasons are given for his conclusion. Read the conclusions first, and then you please come back to the reasoning which he gives. That will make it more interesting. Let's go to the next. I'll now shortly wind up. Next slide, please. Yeah. What are other examples? Like, I have not included many, like Indira Gandhi's case, I didn't mention because of shortage of time. But you take, for example, Minerva Mills. What did Minerva Mills do? The 42nd Amendment tried to set at naught Kesan Bharati. They didn't succeed in this review case. Then they had this 42nd Amendment where they simply said, any amendment of the Constitution from 1950 onwards shall not be questioned on any ground whatsoever. So every amendment became judicial review proof. Nobody could question any amendment. Supreme Court very interestingly said, amending power itself is subject to judicial basic structure, and they struck down those provisions, 4, 5, and 52 of the 42nd Amendment Act. The amendment to 368 was struck down. Then SP Gupta's case, very interesting. This is again shows the importance of interpretation. The word used in Article 124 is consultation. In 1982, consultation doesn't mean concurrence. Now take SP Gupta's case. It's very fascinating how consultation in 1982 meaning it means only consultation, that you have to only, that judiciary doesn't have the last say, the executive has the last say. How does it become concurrence? How and why? There again, the hydraulic pressure theory, what happened in society, why was this necessary? Why had to give a purposive interpretation to 124? Of course, it has got a lot of critics. People say there is no basis for completely changing this. But again, they've used different methods of interpretation. A lengthy judgments have been given by people and said why ultimately judiciary must have the last say in judicial appointments. So consultation becomes concurrence. Take Madras Bar Association, where the National Tax Tribunal Act was struck down. What did the Supreme Court say? In our constitution, take the structure of the constitution. This is a classic structural case. Core judicial functions. What are questions of law? Decisions on questions of law. They said this can never be given to a tribunal, and they struck it down. And finally, I'll go to Puttaswamy's case, the privacy case. Where is privacy mentioned in part 3? Nowhere. Where is it mentioned in the American Constitution? Nowhere. Yet, take Puttaswamy, privacy. Take Justice Nariman's judgment. He traces it to liberty, fraternity, 19.1a, 19.1d, 21. It's called. He says privacy permeates throughout part 3. Now you have a case where privacy has become a fundamental right, although it's not mentioned anywhere. This is the beauty of constitutional interpretation. As times have gone by, as we have crossed almost 70 years of our independence, what fundamental rights were actually given. We have now introduced a new right, which is privacy. And this judgment is an excellent example of judicial creativity and judicial interpretation and introducing privacy as part of fundamental rights. Last point.